Mr. Chandra, can you talk to us a little bit about this second lawsuit that was filed just today?
Yes, so we filed a federal civil rights lawsuit in the U.S. District Court for a family that has been through a great deal. It's on behalf of a young girl and her mother. And the allegation in the suit is that when she was just right out of grade school and still, she says, playing with dolls, I mean, developmentally young, she arrived at Ursuline in the summer before the freshman year and was taking a gym class. And there was a football player who she's under 5 feet tall, and he was 6 foot. She's all of 120 pounds. And she was, persistently sexually harassed and solicited for sex by him. She very innocent young girl out of grade school. She just declined his overtures. But nevertheless, he was persistent. At some point, she alleges that then escalated into a violent incident where outside he picked her up and chased her, picked her up, threw her hard to the ground, and then dragged her across some rough turf, resulting in severe turf burns to her back. That is photographed and depicted in the complaint. She and her mother then reported this to the assistant principal, Ms. Damore, and the allegation is that Damore was indifferent and hostile, and in fact, even specifically warned the mother, I strongly advise you not to report this to the police. Now, this was a football player. This was a person identified as player number 6, also in the hazing complaint. And the allegation of this complaint is that then, over a period of time, despite asking for help and actually extracting a promise, perhaps a reluctant one, from the principal, the suit alleges that despite that promise, that come fall, she would separate these kids in a classroom. That did not happen. This girl wound up in the same classroom with her alleged assailant, and he continued to engage, the suit alleges, in harassing conduct, including ogling her and making overtures again and sending surrogates to her saying he wanted to get with her and so forth. She kept declining, and she did report this several times to the school, asked that it stop, asked that she be separated. The answer was no. And finally, this continued over the course of 2 years. And then finally, she had a meeting with the assistant principal, the suit alleges, because she herself was being disciplined for some relatively minor infractions, and yet she was receiving a severe consequence. The suit alleges that that was retaliatory because of her reports, because in comparison to others' misdeeds, including a physical assailant who seemed to get no consequence, she finally asked the assistant principal, the suit alleges, you're not going to help me, are you? And the response, according to these allegations, was a simple no. Um, it's further alleged that the uh, alleged perpetrator here, the assailant, then called her a snitch and said, that she tried to get him in trouble, but it's not going to happen. And from this, the suit infers and alleges that what was happening was that even the football player understood, and this is consistent with the allegations in the parallel lawsuit regarding hazing, that football players understood that they were really above accountability in this culture at Ursuline. And the consequences of that can be devastating for victims like our client. Ultimately, after 2 years of this, the mother had enough. She wanted to protect the safety of her child, and she needed to. So she finally made the difficult decision to sell their family home of 28 years and move so that she could put this child in a different district where she is today.
Wow. If I have this correctly, we're talking about the first federal, the player in this lawsuit is also named in the first lawsuit.
Correct. It's the same designation, the same pseudonym, player six in both lawsuits.
So the victim in this case says this happened in June 2023. This has been more than 2 years and nothing, no investigation, nothing was done.
Well, that's her belief, and that's what she's alleging in the suit because she repeatedly kept going to the principal. And again, the allegation of the suit is that the mother extracted an apparently reluctant promise
Mhm.
from Assistant Principal Damore that she would address the issue in the fall, and that the students would be separated. But that didn't happen. They were assigned to the same class that fall of 2023, and again it happened in the fall semester of 2024. So this poor young girl, complained about it and kept raising her voice over it. And actually, the suit also alleges that her elder brother was deeply disturbed by this, and he's an alum of the school. And he reached out to the athletic director, who's also a co-defendant here, and asked for action, and action never took place. And he was bemoaning the fact that no action was taking place and expressing his concern and disappointment and expressing concern about the safety of his sister. Now, all of this is important in the context of the legal claims, because the legal claims here include a violation of federal Title IX, which folks may be familiar with. That is the federal civil rights protection against sex discrimination and sexual harassment in education, in the field of education. And that includes K through higher education. It includes an allegation of Title IX retaliation that the assistant principal here was retaliating against this girl out of anger for her having so persistently complained about her situation, all allegedly to protect the football team and to protect this football player. It states allegations under Ohio state law that are actually criminal violations, but that can be turned into civil claims and also have a separate civil component. And that is that administrators, coaches, and teachers are all considered mandatory reporters under Ohio law. The statute is clear and unambiguous that if an administrator, coach, teacher in a school becomes aware of an instance of child abuse, particularly one where there might be serious physical injury, as was the case here, as depicted in the photograph, then in those circumstances, they must report. It's not optional. They must report to law enforcement, children's services, or both. So uh, when this child and her mother and her brother are repeatedly and persistently asking for action and it's not happening, what this suit is alleging is that's now intentional. That's
Mm.
not just at the low standard of negligence. You didn't do something you were supposed to do, like we think of car accidents. Hey, I was accidentally distracted. I looked the other way. I looked at a pigeon and I had an accident. No, we're not talking about mere negligence. This suit is alleging intentional conduct, reckless conduct, where in the face of known danger, there's conscious disregard for the rights of this child. All apparently the suit alleges to protect the football team
I want to
and the
ask
football
you,
player.
attorney. Thank you. My apology. I want to ask you, Attorney Chandra, did this victim, did she come forward after the first lawsuit was filed?
Yes. So a couple of days, we heard from her a couple of days after the first suit was filed. Apparently, it took a couple of days for it to sink in. And she and her mother finally had the courage and fortitude to come forward and make their allegations about what their experience had been. And their motivation, similar to the other family that we represent in the hazing lawsuit, is that they want to see accountability. That when they read the other suit, they realized they were not alone. They realized that the loneliness and isolation that they felt and the frustration of essentially asking for help and being denied help, in fact, even affirmatively to your face, being told, no, I'm not going to help you, that under those circumstances, they felt that they needed to really come forward and be voices, perhaps even for other people, not just themselves, who may have been victimized by any indifference at the school, particularly if it surrounded protecting football players and the football team in wrongdoing. Um, this is a very serious matter for them. This is a child who's taken an enormous and courageous step in having her voice be heard. It's similarly awkward and difficult for the boy in the other case. We have heard from other victims, and we've assured these clients they are not alone. There are others. We are investigating those other matters. We anticipate that we will have additional lawsuits filed over the coming weeks. We are asking and urging other alleged victims or witnesses or both to come forward, even if they don't want to pursue legal action, and even if legal action isn't possible, say, for example, because of the expiration of a statute of limitations. It's important for those who've had the courage to speak up. It's important for the other victims out there that they join forces, speak with one voice, be heard, because these two families are certainly determined to hold the diocese and to hold Ursuline accountable for the conduct that is alleged here.
Mr. Attorney Chandra, at every level, it seems there were so many failures for the safeguards that were in place to protect these students. Can you talk about why did it take so long for all of this to come out?
Well, that's not really for me to answer. That was probably something for Ursuline and the diocese to answer. But what I can tell you is that from my experience in my practice, is that victims of sexual assaults, violence, are often living in shadows in our midst with their secrets, and they're living with shame that they don't deserve to be feeling, but that's what they're living with. And I think that's true of these two clients as well. It's certainly true of the boy that we represent. There's shame and feelings of shame and humiliation and depression. And, they're finding their voices and they're speaking up. Um, it's really, I think, a matter of time now that we're hearing from other victims and we're investigating their circumstances. It's really only a matter of time that there's a full accounting for the conduct at Ursuline.
And that's my next question. What does full
Yeah.
accounting look like? What does
Well,
justice look like?
so these, yeah, when you file a civil lawsuit, as contrasted with, say, criminal justice, then one of the primary objectives is to obtain money damages to compensate the victims who've experienced things that can't otherwise be compensated. Like when you've experienced the kind of depression that's alleged, for example, in the girl's suit, where she couldn't even go to school for 35 days, and just didn't want to be there anymore and wasn't enjoying that time of her life. There needs to be compensation for that. But that's really, in so many ways for these families, secondary to seeing and accounting across the board, from the diocese level, to the extent that there were poor decisions about hiring, poor implementation of training, supervision, discipline, accountability, vis-a-vis the school administrators. And then at the school, from the administration to the coaches to the players. And one of the things that's been so interesting about Ursuline's public statements in the last few days, they're kind of, they seem to be missing the point. First of all, where is the expression, the true expression of compassion for the victims and a determination to reach out and to try to resolve these issues? Totally absent from those statements. A statement about two coaches being put on administrative leave and the head coach being indefinitely suspended by agreement. It's hard to interpret what that means other than, well, we need to sideline them while we investigate that. That's the best interpretation. The worst interpretation is we're doing damage control. And yet, total silence with respect to the allegations against the administrators, and complete and utter silence with respect to the players. Now, in part, we understand that because there are educational privacy concerns, but there's still not even an expression that, look, we understand what happens here. We've seen the videos, we've seen photos, we understand the magnitude of what's happened here. We feel compassion for these victims, and we understand that players who've engaged in misdeeds need to be held accountable. And frankly, the football season be damned, right? So while it's not an objective of our clients to somehow ruin the fun of football at Ursuline, the fact of the matter is that in the normal world, actions have consequences. And part of growing up, even as a child, as a youth, as a teen, is learning that your actions have consequences. And if those consequences for children who participated in sexual acts without consent, and perpetrated extreme hazing, to those who stood by and did nothing, to those who recorded and thought it was funny to record and disseminate and share child porn effectively. There have to be consequences. And so what we've seen is silence from the diocese, silence from Ursuline, and that has put our clients in a position where in the litigation, they're just simply determined to move forward and hold everybody to account. When really what ought to be happening here is everybody stepping back and saying, we have to do what's in the best interests of the children who are perpetrators, the children who are victims, the children who are bystanders, the children who are innocently having the name of their school tarnished, perhaps by allegations against administration and players. So that's what real compassion and problem solving looks like. And my clients across the board are very disappointed. I mean, they've been disappointed all along that there's been a lack of accountability. So you can't really exactly call them shocked that the adjustments by Ursuline and the diocese are happening in dribs and drabs, but they are happening only in dribs and drabs. And here's what I can tell you from my experience in doing crisis communications as a private lawyer for the city of Cleveland, for
Mhm.
large institutions. I mean, every crisis communication specialist, whether they're a lawyer or just a communications professional, understands that this is what you do. You tell the truth, you tell it all, you tell it first. That's what you do. You rip the Band-Aid off and you get to the bottom of it. You accept responsibility. You hold the people that were responsible. But you don't sort of play these communications games where you say nothing happened, and then have these meetings with the parents where you say, nothing happened here. This is all just, lawyers with rival teams. And I mean, it's just, none of that makes any sense. None of that makes any logical sense. And from what we're hearing, the parents understand that. The parents of these football kids understand, most of them, to our understanding, have a pretty good grasp
Mhm.
that this got out of hand and things need to be done. And that the statements from coaches and the statements from administration and the statements on letterhead don't make any sense. The community is rejecting all of that as well, if you look at social media sentiment. Now,
Yeah.
why is all of this important? Why am I sharing this with you? Because it's reflecting the concerns of my clients about how this whole situation needs to be approached. And it's reflecting their desire that I say, once again, we want to hear from other victims. We want to hear from witnesses who have truthful information to share, because that collective airing and sunlight on what was in the dark corners is going to wind up being the best disinfectant under these circumstances, because it doesn't look like it's going to happen on its own. We're going to have to keep moving forward with getting the truth out.
Do you believe that there's a pattern there at Ursuline High School?
Well, I think between the complaint on hazing, all 200 pages of it, detailing the culture, the incidents, the cover up, allegations, combined with this latest complaint involving another incident involving a football player involved in the first situation, when you look at all of that collectively, it does seem to suggest a pattern of misconduct. In fact, the complaint itself, this latest complaint on behalf of the young girl, refers to a modus operandi, a way of doing business, a mode of operations. And we believe that that's going to be further reflected based on the investigations we're doing now and the forthcoming complaints we have coming, which is why we're saying to victims now, there is strength in numbers. You're not alone. Come forward. let's get all of this out and let's make sure that the truth is known, because that might cause these systems to self-correct and for there to be accountability from the decision makers.
Okay. Attorney Chandra, what happens next?
Well, we are going to be conferring with counsel for the other side a little bit about some of the logistics of litigation, which includes the need to serve the complaint on people whose addresses we don't have at this time. So we either get cooperation from the institutional defendants on that, or we have to go to the court and get a court order ordering information to be released. And then in the litigation schedule now on these cases, lawyers are supposed to the defense lawyers are supposed to file responses to the complaints. Then at that point, they meet, confer, they start to propose a schedule to the court, and we start moving on discovery. Our hope is that by the time as many of the allegations as can be aired are aired over the coming weeks, that there will be an appetite for a resolution on which all sides can agree. But we're not, and our clients aren't counting on that right now.
And I think most would agree with you, football season be damned. But we just recently got news that they canceled, Warren G. Harding canceled the game next week, September 19th. And we're hearing about some other schools possibly canceling the game. Do you have any response to that?
Well, I can't really comment on that because it was never our objective through these two pieces of litigation or our client's objective to somehow, ruin football for a community that enjoys it. That's certainly never been the objective. What was the objective was accountability. And so ultimately, what the clients care about is that the players that they have alleged participated in misconduct, whether they're named as defendants or not, whether their parents are named as defendants or not, that there be a full accounting and proportionate allocation of responsibility and discipline for what has transpired and what is alleged to have transpired. So that's really their objective.
Hmm.
It is understandable, of course, to our clients that there are going to be other schools that are going to have to make their own decisions about what they think is best for their children, for their community.
Hmm.
So that's understandable. But really the objective here for our clients is to see the administrators, the coaches, the players who are responsible for what has transpired across both cases held accountable in a way that is as transparent as can be, consistent with the law, so that people can have more confidence in our institutions. I mean, I think this is a very important point to make. For both of these children, for both of these children, this episode is traumatic, not just because of violence perpetrated, not just because of harassment endured, which is bad enough as it is, and not just because of physical injuries and pain suffered by this young girl. It's not just that, it's that they lost their faith in adults. They lost their faith in the authority figures. They lost their faith in these faith institutions.
Yes.
And that's a robbing of childlike innocence that no child deserves to experience. And what the consequences of that will be over a lifetime, really, I can't fully articulate now. We're going to try to understand that. But what we hope and what their parents hope is that out of these two pieces of litigation will come not only accountability, but also a sense of healing, because these children who were forced to grow up far sooner than they should have because of what transpired will feel that they did something right for themselves, for
Hmm.
others, and for the community. And that's certainly what I hope as an advocate. But I can see that they are hurting, that this is even the whole experience. I mean, imagine you're 13, 14, 15 years old and you're being interviewed by state, federal, and joint, excuse me. Imagine being 13 to 15 years old, 16 years old, and you're now being interviewed by the FBI and BCI and Youngstown PD, federal, state, and local law enforcement. I mean, imagine that, how shocking and traumatizing that might be. And you're being required to tell things you don't even want to talk to your parents about or your siblings about. So that's what this experience is like for them. It's painful for us as advocates to see them endure that. But, we and their parents are very proud of their courage and determination and their willingness to speak their truth and be
Yeah.
heard. And hopefully we've said to them, inspire other people to stand up for themselves as well.
Okay. Is there anything else you would like for us to know?
No, just I want to reiterate one last time. We encourage any additional victims and witnesses to please come forward. You can visit chandralaw.com, and you can use our secure contact form there. We welcome any information. We've received a lot of information. You won't be alone.
Thank you, Attorney Subodh Chandra.
Thank you.